You know, nothing phases Martha.
No.
John, that's it. Stone cold and to the point.
Or the congressman.
That's right. Breaking news from the Supreme Court and a legal setback for the Obama administration. The justice is limiting the president's power to make temporary recess appointments. The High Court ruling Mr. Obama exceeded his authority by filling slots on the National Labor Relations Board 2 years ago. We're going to get a little bit more into that. It was big news today and is big news. Hello, everybody. I'm Jenna Lee.
Good Thursday morning to you. I'm John Scott. The Supreme Court making the decision on recess appointments, also ruling that a ban on protests outside abortion clinics violates the First Amendment. Tom Goldstein is the founder of SCOTUS blog and a Supreme Court litigator. Did this ruling on the National Labor Relations Board, the president's power, calendar scheduling of recess appointments, did it go the way you expected? Tom, you able to hear me? All right, we apparently do not have our link up to Tom Goldstein. He is the founder of a widely read blog about the rulings, the inner workings of the Supreme Court. SCOTUS blog, it's called. When we reestablish our link to Tom Goldstein, we'll take you right back to the Supreme Court.
He's definitely the one to talk to about all of this. So we'll be back to him in just a moment.
Let's get back to those big Supreme Court rulings just issued today. One of them saying the president exceeded his authority when he made appointments to the National Labor Relations Board 2 years ago, while the Senate, he said, was in recess. The Senate said it was not. Tom Goldstein is the founder of SCOTUS blog and is able to hear us now. Tom, did this ruling in that National Labor Relations Board case, did it go the way you expected?
It did. It was pretty clear from when the justices heard oral argument in the case that the administration was going to lose, that these recess appointments and others were going to go down because the court believed that presidents for a long time, but particularly the most expansive reading of the recess appointments power by President Obama, had just gone too far. And it's a broad ruling. Even though many of the arguments against the recess appointments power were rejected, really the core one was accepted by the Supreme Court. And it says, in essence, that if either the Senate or the House of Representatives wants the Senate to be in recess, then there can't be a recess appointment.
And every president in recent memory makes recess appointments. What was different about this one?
It was the short time that the Senate was away. The Supreme Court said we don't have a problem with the way this has been done historically, but it has gotten so nasty between the Congress and the President that it got to the point that the Senate would take what are called pro forma sessions. They would come in and gavel out and not do any work. And President Obama said, I'm going to ignore that. I'm not going to act like you are actually doing business when you're not, as a practical matter. And the Supreme Court said, no, you've got to pay attention. If the Senate says it's in session, and you cannot make a recess appointment. And given that the House of Representatives, controlled obviously by Republicans, can force the Senate into that kind of recess, President Obama is stuck now. And if a Republican wins the presidency and a Democratic Senate is in place, well, then they'll be able to block recess appointments too. So it's a very big decision.
Talking about Republicans, we have this from Mitch McConnell, the Republican leader, minority leader in the U.S. Senate. He says this administration has a tendency to abide by laws that it likes and disregard those it doesn't. In this case, that disturbing and dangerous tendency extended to the Constitution itself. Whether it's recess appointments or Obamacare, this troubling approach does serious damage to the rule of law, and the court's decision is a clear rebuke of the administration's behavior. Do you see it that same way?
Well, obviously the Supreme Court rejected the constitutional challenge to Obamacare, but when it comes to recess appointments, Mitch McConnell can't be more right. This was a very expansive reading by the president of his power to put somebody in office, though they haven't been confirmed by the Senate, and a unanimous Supreme Court, in an opinion by a Democratic appointee, Stephen Breyer, rejected that.
Also, this ruling on abortion clinics, protesting outside abortion clinics or the ban thereof, violates restrictions on free speech. Tell us what the thinking is there.
Sure, another very broad ruling from the Supreme Court in terms of the majority, and that is liberals, conservatives on the Supreme Court all agreeing that Massachusetts went too far when it said that abortion protesters get moved off of sidewalks and driveways and public streets that are right in front of abortion clinics. The justices said you can't go that far. It violates the protesters' right to communicate, to counsel, to protest. Instead, what you have to do is you can pass a law that says you can't obstruct obstruct the clinic entrance, and the police can enforce that law. But until we know those narrower measures that are really targeted to women being able to get in and out of the clinic, until we know those don't work, you can't go as far as Massachusetts did. That is a very broad ruling, very significant for protesters and counselors outside of abortion clinics around the country.
So do you see it as a win for free speech?
Well, clearly it is. There are people who don't agree with the speech, but the Supreme Court has been consistent in saying we don't really care what the speech is. We're going to protect your right on a public sidewalk. They were not that sympathetic to the clinic's argument, to Massachusetts' argument that these protesters inevitably make it impossible to get into the clinic. They said there's been no record of that. We haven't seen prosecutions of people blocking access to the clinic. One thing is the case, though, and that is the justices didn't subject these buffer zones to strict constitutional scrutiny, which is lawyer speak for really, really rigorous First Amendment protection. They said this is a relatively easy case. The state went too far when it has a simpler way of protecting clinic access.
And still waiting for the ruling in the Hobby Lobby case. That's one of the big ones of this court term. When might we expect that, Tom?
We actually know that. The last two decisions, including that critical contraception mandate from Obamacare decision, will come down at 10 a.m. Eastern on Monday. And we have one other very significant kind of sleeper case out there that may determine the future of public employee unions.
All right, we'll be looking for those on SCOTUS blog, and also we will be holding that breaking news when it comes out on Monday morning, as you say. Tom Goldstein from SCOTUS blog, the founder there. Tom, thank you.
Thanks, John.